Hello everyone, I am Ankit and you're watching Study IQ IAS English. And in today's video, we'll be understanding the reasons why Platform X, which is a platform owned by Elon Musk, has filed a case against Government of India in the High Court of Karnataka. Now, the context of this discussion is that the Platform X has filed a case against Government of India against its use of Section 79(3) of the Information Technology Act 2000, and government uses the power provided under it, particularly through this section, to regulate content on social media. And the Platform X, which was formerly known as Twitter, it felt that the use of power of the government under this section is actually a misuse of the power, because there are certain safeguards on how government can regulate the content posted on social media platforms like X, which is given in another section of the IT Act, not under Section 79, but under Section 69A of the IT Act. So let us try to understand first of all, why does government first of all regulate the content on social media? Because isn't freedom of speech and expression a part of fundamental right? So don't you think people have an absolute freedom of speech and expression in India? The answer is no, because although Article 19 of the Indian Constitution provides you with the right of freedom of speech and expression, but this fundamental right is not an absolute right. Rather, it is a qualified right. That means the exercise of freedom of speech and expression in India can be regulated by government under the conditions of reasonable restrictions. What are reasonable restrictions? Do not worry, I will tell you in our today's discussion. Okay, now you have to understand, in the field of information technology, like what you can post or what you can't post on social media platforms like X, Instagram, etc., these are regulated by the government under the provisions of IT Act, which was passed in the year 2000. Now there are basically three regulations or three sections of this IT Act which allows the government to regulate content posted on the social media. These are Section 66A, another one is Section 69A, and the last one is Section 79, subsection 3 and B. So these are the three sections given in the IT Act which allows government to regulate content on social media. So let us try to understand what are the powers that the government has under these three respective sections, and why is there an issue that the Platform X has filed the case against the government over the use of this particular section. Now, as you can see, Section 66A of the Information Technology Act 2000, it allowed the government to criminally punish anyone for posting a false information on the social media platform, and these false information could cause annoyance and inconvenience to the people in general, and that is why the government under Section 66A of the IT Act had the power to criminally punish an individual. Now, government of Maharashtra actually used this particular section of IT Act to punish a person in the state of Maharashtra, and it created a lot of controversy. It created a controversy on social media, as well as this matter reached the apex court of the Indian country, that is the Supreme Court of India. Now, Supreme Court of India heard this matter under the case known as Shreya Singhal versus Union of India case, and the judgment of this particular case was formed or filed by the Supreme Court of India back in 2015. Now, in the judgment, Supreme Court actually highlighted that the use of government's power to criminally punish anyone for their post on social media platforms under Section 66A was actually unconstitutional, because this provision provided government a very wide power to punish anyone, and this was a very vaguely worded kind of a provision, and this vaguely worded provision allowed government a very broad and sweeping powers to stamp down on your freedom of speech and expression. And what we have understood in our today's discussion, government does not have unlimited power to stamp down on our freedom of speech and expression. Only those freedom of speech and expression that violate some conditions as given in the constitution, only that can be restricted by the government. Understood? So technically Section 66A ceased to exist after the Supreme Court ruling in the Shreya Singhal versus Union of India case. Now, after section 66A was invalidated, the government then resorted to the use of section 69A of the IT Act to regulate the content on social media. So it became the primary law based on which the government governed the overall process of social media regulation. Now this section in general, it allows the central government to issue orders for blocking of any information which is transmitted, generated, received, stored in any computer source, which also included social media platforms. But unlike 69(6)(a), which provided very wide powers to the government, section 69(a) only provides certain conditions based on which government can regulate and even restrict the content on social media. So what are those conditions? Let us try to understand this. Now, for blocking any content on social media, as per the provisions of section 69A of the IT Act, government has to first provide that it is absolutely necessary for the government to remove that kind of freedom of speech and expression. And what is the conditions based on which government can remove the content on social media platform? This is the condition which is also provided in the Article 19 subsection 2 of the Constitution. This provision actually says that government can indeed impose only reasonable restrictions on the freedom of speech and expression. And what are reasonable restrictions? For example, any freedom of speech and expression or any content on social media, if it puts into danger the interest of sovereignty and integrity of India as a whole, it impeaches or it endangers the security of the state, it determines or it is detrimental to the friendly relations of India with any foreign country, it disturbs public order, it is against the ideas of decency and morality, or it is against the relation of contempt of court, defamation or incitement of an offence, then in these conditions the central government can impose restrictions on use of freedom of speech and expression. And based on this very condition, government actually can restrict any content on social media if it feels it violates these kind of conditions. So under the powers that the government has under section 69A, this is not a wide power, rather it is a very restricted power that government first of all has to highlight that this is a necessary condition, and therefore in emergency cases it can use certain restrictions on freedom of speech and expression. Now these days government also relies on a very third section of the IT Act, that is section 79 of the IT Act. Now this section in general, it provides immunity to the social media platforms on the content which is posted by users on the social media platforms. For example, if you and I, we post some kind of a reels on Instagram, or if we make certain kind of tweets on platform X, then in that cases the social media platforms that are Instagram and Twitter won't be liable for any content which is posted by you and I. That is called as a safe harbor provision, and it provides intermediaries like social media platforms an immunity from any prosecution that the government does on such kind of tweets and content on social media. But these safe harbor provisions are only available to the social media companies in case they don't edit or curate the content. So if any of these organizations, if they edit the content or even curate the content, then they are not liable for immunity under safe harbor provisions. And there is also a third subsection of this particular act, which is section 79 subsection 3B of this act. It states that if government feels that there is any content on social media which actually imposes danger to the security of the country, or it imposes danger to the friendly relations of India with another country, so in that case government can issue an order to these social media platforms to remove certain kind of content on their platform, and these intermediaries are liable to remove such content which is actually provided to the government or provided to these platforms by the government. So the companies are liable under this provision to remove content if the government or their orders direct the social media platforms to remove certain content. So this is how section 79 works. Now what the government has done, or the Supreme Court has done in the Shreya Singhal case, that it limited how the government will use its power under section 79 subsection 3 of the act. The Supreme Court said that only those content will be removed by social media platforms if a court order has been passed in that regard to remove certain content from social media, and also if government issues a notification in writing stating that certain content on social media violates the ground which is given under section 19 subsection 2, and only in these cases the social media platforms will remove content on their platforms and not by any order of the government. Understood? So this is how government's power under section 79 works in general. Now, to use government's power under section 79I, what the Ministry of IT has done, that it has issued directive to all ministries, departments, state governments and police, saying that information blocking orders can indeed be issued under section 79 subsection 3 of the act, and for facilitation of these removal of the content and issuance of the order, the Ministry of IT has created a platform known as Sahyog, where the aforementioned authorities will issue and upload their blocking orders. So this is how the use of section 79 is done by both central and state governments in general to remove content from the social media website, and this issue has actually reached the Karnataka High Court. And why this issue has reached Karnataka High Court? Because the platform X says that use of such power by the government under section 79I, it bypasses the multiple procedural safeguards which are laid under section 69, and according to the platform X, the government can only censor content through the order section 69A, not under section 79. And as per X, section 79, it indeed provides the social media platforms like X the immunity from any content which is uploaded on their platforms by third party, like individuals like you and I. Understood? So this is the grievance of platform X, that it is saying to the court that government can't use its power under section 79 to remove the content, because this power is available to the government under section 69A, which actually has certain kind of restrictions on how the government can use this power. Understood? Also, why this kind of a news becomes relevant from our news perspective, and why it becomes relevant from our exams perspective, because in that case you have to regard the X's petition in the Karnataka High Court is issued at the time when its AI based chatbot known as Grok 3 has been quoting controversy. And why this chatbot is quoting controversy? Because it gave certain kind of responses which was against the it was very critical of the government. Also, the responses given by this particular chatbot was laden with profanity and abuses. So therefore, it created a lot of controversy. Now, why is this controversy relevant? Because I told you, right, under section 79A, if any individual like you and I, we are posting some content on social media, the social media companies are not liable for that kind of a content, because this is a matter between me and the law authorities, and the social media, they're just acting as an intermediary by not editing that content. So they are technically immune from any government's action. So this is a immunity that is provided under section 79I, known as safe harbor. Now this was related to the content which is posted by people like you and I, but what about the content posted by AI based chatbot which was indeed trained by the platform X? So is platform X liable in the cases such content it violates article 19 of the constitution? This is to be determined by the courts, and we'll do a separate video on this kind of an issue, right? So that is why such kind of a news is relevant. Now there is also a practice question for you to solve. Please try to solve this question. This is very similar to a question which has appeared in the prelims examination, and also for similar contents on various current affairs related developments, please do follow the Study IQ IS English channel, and also do not forget to hit the like button and let me know in the comments what do you feel about this particular issue. Is the platform X right, or is the government right to regulate content on social media? What do you feel about it? Please do let me know in the comments, and I'll take your permission. Please like the video and also subscribe to our channel.